I'm Sam. Welcome to Sam Explains. This message is for parents who have an open CPS case. If you are getting towards the end, there's something very important you need to know about, and that is reasonable efforts. Before the state can take away your rights, your parental rights, and take away your child forever, they must legally prove reasonable efforts. That is where the state, CPS, the caseworkers, help you reunify with your child. And they have to document that. So let me tell you a little bit more about that, because it's really important to know at the end, getting towards the end of your case. And also please know, in most cases, the goal will be reunification. And very often, towards the end, all of a sudden the goal will change to adoption. I think it would be good as a parent to expect that to happen. It happened to me, and it happens to most parents. I completed my case plan. Everything was going along in the right direction, and all of a sudden, for no reason, they changed the goal from reunification to adoption. Reasonable efforts is a legal duty of CPS. It doesn't mean they give you a case plan and you're supposed to complete it. That's not reasonable efforts. There's more to it than that. And CPS is legally required to, with reasonable efforts, reunify a family. Every state receives federal funding, and part of the agreement in receiving all of that money, the states, CPS, are supposed to actively, with intention and effort, keep families together, and if separated, they're supposed to put in this intention and effort to reunify a family. They are financially, legally obligated to do this. And if a parent were to prove that CPS didn't provide reasonable efforts, they lose funding. My personal opinion is CPS cares about funding, not families. And so when you have a claim with evidence that can hurt their funding, things that you want become taken more seriously, if you know what I mean. Before terminating your parental rights, before adopting your child out, the state has a legal responsibility to offer you reasonable efforts to keep your family together, to reunify your family if you've been separated. I want to read this to you. Reasonable efforts means the agency has to be actively working with you to fix whatever they said was unsafe. Not just check the boxes. Not just referring you to services, but truly trying to keep your family together. Because every state receives federal funding to run the child welfare system. They are required to make reasonable efforts to reunify families. Some examples of reasonable efforts: creating a reunification case plan tailored to the parent's actual needs. If you have an open CPS case with a safety plan, your case has gone judicial, your child has been removed, sometimes you find that your requirements of your case plan are overlapping or not even necessary or needed. So the emphasis on tailored to the parent's actual needs. Another example, offering in-home safety services instead of removing the child when possible. In my story, our second day at the family-centered homeless shelter, CPS came and ripped my 3-year-old and 18-month-old from my arms and took my first grader and my kindergartner from their school. Nothing was offered to me. No assistance with housing for getting on my feet after leaving my abuser. Nothing was offered to me. They came in and took my kids and never gave them back. Another example, exploring relative or kinship placement before foster care, helping arrange safe housing, that would have been nice, or shelter if homelessness is the issue, referring the parent to substance abuse treatment, parenting classes, mental health, domestic violence, making services available in the parent's language and geographic area, paying for or arranging transportation to those services. That's a big one that I hear parents struggling with often. CPS is supposed to make sure you have transportation not only to your services and classes and things for your case plan, but to your visitations with your children. And CPS adjusting the case plan when the parent is doing well or progressing, setting up frequent and meaningful visitation, increasing visits when the parent is compliant, providing a visitation coach or therapeutic supervision to strengthen the bond, providing wraparound support, allowing the parent support system to be involved in the case planning, working with the parent on trial home placements once safety is established. It is super important that your visitations consistently move forward, meaning that they increase, meaning that they become less supervised. That is so critical for reunification, is making sure your visits happen more often and become unsupervised, and then get to that overnight on the weekend phase. That pretty much guarantees you reunification. If your visits aren't consistently increasing, you need to get on your attorney's ass. The judge decides visitations, not CPS. They are court ordered by that judge. And so if your visitations are not moving forward, you need to stay on top of your attorney, demand, advocate for your family by increasing the visitations. If you have a hearing coming soon, your lawyer can ask at any hearing. If you don't have a hearing coming soon, your lawyer can file with the court a petition for more visitation, and there will be a specific hearing just for that. And it's so super duper important for reunification. Some more reasonable efforts. Recommending reunification in court when the parent meets the case plan. That rarely happens. CPS rarely hands you your kid back. If they were reasonably putting in effort to reunify your family, they would. But I don't know if I've heard of any case where they recommended in court reunification. You have to ask for it. Again, your attorney. Petition the court for reunification. Submit a reunification plan, which is something you submit to the court that is a detailed description of how you're going to integrate your child back into your life. And filing reports that show the parent's progress and strengths, not just deficiencies. Good luck with that. Your progress and strengths are things that you need to be collecting along the way, that you can hand to your lawyer as evidence. If your case gets to termination of parental rights, you're going to want that evidence that shows your progress and your strengths. And last, and I hate to keep reading, but this is really important, I want to read to you what it looks like when CPS submits to the court that they have completed their reasonable efforts. I want you to hear this. And also, please know that it is super important as you get towards the end of your judicial CPS case for you to ask your attorney to, and then your attorney will request it from the court, that you want in writing CPS's reasonable efforts. As I said, they're legally required to do this. They are legally required by the federal government to put in the effort to reunify your family, and they have to prove that to the court. They have to put it in writing. And so you need to tell your attorney that you want a copy of that. And this is what it should sound like. The department has made reasonable efforts to prevent removal and to reunify the family, including referring the mother to a parenting education program, which she successfully completed on, providing the mother with bus passes and mileage reimbursements for all scheduled services and court hearings, referring the mother for a psychological evaluation and arranging counseling services consistent with the evaluator's recommendations, offering supervised visitation twice weekly and increasing visitation to unsupervised weekend visits after the mother demonstrates sustained progress, exploring relative placement, conducting monthly case management meetings with the mother to assess progress and adjust services as needed. Based on these actions, the department asserts that it has fulfilled its statutory obligation to make reasonable efforts towards reunification. Okay, this is the last part for real, and this is the most important part. If CPS did not provide transportation, did not increase your visits, did not adjust the case plan when you progressed, or if they pushed towards adoption in any kind of way, then you have what you need to challenge reasonable efforts. And it's a good move. Talk to your lawyers about it. I'm not giving legal advice. You don't want my legal advice. I give experience advice. And so reasonable efforts. If you don't think that CPS has done everything they can within reason to reunify your family, then you need to talk to your lawyer about that. You need to request from the court what CPS submitted in proving that they did reasonably put in efforts to reunify your family. These things I just gave examples of and listed is what they should be doing. And if they didn't do these things, like provide transportation, increase your visits, then you can challenge that in court, and it affects their money. So it's a good move to make. If reasonable efforts didn't actually happen, CPS is not supposed to move towards termination of parental rights. Mothers are what's best for children. I don't want any mother's case to be moving towards TPR. So I hope if you are in that situation that something was valuable for you in today's video. I want all children to reunify with their mothers. Mothers are what's best. If you have any questions or just want to do a check-in, I'd appreciate that in the comments. Subscribe. It helps get my content to more mothers. And I think that this is important. And spreading awareness saves more children. And that's the most important thing. So thank you for being here. See you next time.